Hello and welcome to PM Express. My name is Nana Ansakwa. Now this whole week, Joy FM or Joy News in conjunction with Star Ghana has been taking us through courtroom procedure, court proceedings, just making us understand exactly what went on for the 8 months. Because all through the 8 months, there were too many jargon, some in Latin, which, sometimes we can barely understand English, let alone the Latin. But this week, we're doing the whole thing in English. Why certain things are what they are. And it's been an educational tip. Today, we're just looking at the courtroom setup. I just want to find out that if indeed there is a case, how then do we come to court and decide that I'm not going to bring this evidence, I'm going to bring this? I thought the whole thing was an element of surprise to be able to win your opponent over. But then if he knows that this is how I am going to approach the case, then clearly he's also going to, arm himself against how you're going to come. We're going to ask all those questions and many more. We're even going to divert and go to our rural areas and look at the deplorable state in which some of the courthouses are. Can we take them to the Supreme Court? Indeed, now that we know that the supreme power is the Supreme Court, are they now going to be overwhelmed with cases? Is everybody going to drag perpetrators to the Supreme Court? With me in the studio is Dr. Maurice Ampa, who is the president of the Legal Advisory Foundation, and also lawyer Robert Kingsley Yeboah, a private legal practitioner, and they are going to take me through school. And as I go through school, you will also be going through school. I'm going to take a quick break. When we come back, the conversation will begin. Welcome back to the show, and as I introduced earlier, but I'll introduce them again and welcome them to the show, is Dr. Maurice Ampa, who's a senior lawyer, president of the Legal Advisory Foundation. To my extreme left, and then to my immediate left is Robert Kingsley Yeboah, who is a private legal practitioner, and they're here to take me through school. Now, listen to this. As a chief, I do hear cases every now and then. Now, if Kofi came to me and Yao came to me with their case, maybe Yao might come first, and then I might call Kofi, and then we decide to settle the case on Friday. It's very rare for Kofi to come in and say, with this case that I'm bringing, and I'm not going to mention the fact that he slapped me on my right cheek, and then Yao comes and says, okay, in that case, I'm not going to mention the fact that he kicked my right leg, and then we proceed from there. Where's the element of surprise? Because as a layman, if I was going to court, I want to hide some cards that I'll bring out, and then, the guy on the other side shouldn't know, so that I can floor him and win my case. Kingsley, well, Robert, I'll start with you. But your guys go in there and say, okay, we sort of set the premises of how we are going to do the case. You know what I'm going to bring. I know what you're going to bring. And then we go home, prepare, and then come on another day. So then the element of surprise is gone, isn't it?
Thank you very much, and thank you to your viewers.
Yes.
You'll notice that there are stages in the court structure. Mm-hmm. We have the lower courts and then the higher courts. I'll deal with the higher courts. Okay. That's from the Court of High Court to the Supreme Court. Mm-hmm. Now, that is a court of record. All those courts, the superior courts, are courts of record. So at the end of the day, when you are going to the court, everything that you're going to say must be put on paper. So that if you are starting the case in the normal sense of a case, civil case, where you have statement of claim, you must give an indication, not the evidence that you are going to give, but you must give at least bits of what you intend to say in court, so that your opponent may know what he's also coming to face, and then give you a sample of what he's also going to use to respond to it. So being a court of record, you are required to, as it were, give little bits or tidbits of your case, so that the other person too may give his version of it. That is not your evidence. Your evidence is always something that you will give at the end of the day to bring to the court when you are given the opportunity to give your evidence. So I will say that being a court of record, for the cases in court, you must first give a synopsis of what you are going to say in court, so your opponent may see what he's also going to face and then respond to it.
But that is my point. I don't want him to be prepared. I want to take him by surprise in court.
Well, I will say that in the court of record, there are surprises, but as it were, before you present your case before the court, you must give your brief facts. So these brief facts, by way of the court being a court of record, is a standard that you cannot deviate from. If it is a court, an inferior court where there are no records, then of course you can just start extempore and then give your evidence where the person may not necessarily know. But even that, at the lower courts, you are supposed to bring what you call your affidavit in support of your application for your statement of case. When you are starting the case in the court, if you are found at a district court, you must at least bring an application which must be supported by what you intend to say. So, for example, I'm saying that doctor owes me 50,000. At least I must tell the court that I'm coming to court to say that doctor owes me 50,000. I gave him the money maybe 2 years ago, and he has refused to pay. The time for him to pay has come, and he's not paid. So now give me judgment for that. At least the court must have that gist. So to us as lawyers, we don't see it as a way of surprise. We see it as following the procedure in court, because without statement of your case, the person will not know what he has to answer. In law, you must let the person know what charge he's facing before he can come and answer. For example, in a criminal trial, if you are just brought to court, and then that very day they start telling you you stole something, you not have prepared. So you must be told beforehand that this is the case that we have against you. It is a charge of maybe contempt. Because it's a charge of contempt, then you will prepare yourself to come and face your charge. Okay. Because the law is that an accused person, for example, must be given every opportunity to defend himself. And one of them is that you must know what case you are going to face in the court. So that it's not surprising to you. Then you can adequately prepare on that one.
Okay, doctor. So, Kofi's taking my 50,000. I've taken him to court. I've told the magistrate, look, he took my 50,000. That's why I brought him to court. The case started, and I said, apart from the 50,000, he's also taken another 100,000 of me yesterday or maybe 2 weeks ago. Or is the judge going to tell me, no, you can't talk about the 100,000. You should only talk about the 50 because that's why you brought him here?
Yes. You see, as rightly said by my senior colleague, I think we have to know that the court is there to do what is fair and just. And it's also there to unravel the truth. Mm-hmm. So that it is one of the principles of natural justice that don't never condemn a person on head. So before you want to condemn me, you bring charges against me, let me know fully what charges I'm facing, then I will be able to be heard on its merits so that a decision will be taken. So the court will allow the parties. If the truth is on your side, you don't have to hide anything. If the truth is on your side, you don't hide. You come up with the truth. This is all that I have against you. This is what I want to say. That is the truth. But if you fear coming out with the truth, that means that you are not being honest with yourself. And the court will not allow you to take your opponent by surprise. So bring all your case, your issue before court. Let the person know what he's going to face. Face him with the truth, nothing but the truth.
But sometimes you even give the evidence to your opponent to go and study and then sort of come to court with it. Or, I mean, I don't know if you give the case or...
Let me tell you what happens. Normally, let me tell you, a lot of litigations you find yourself normally ends even with lawyers. When people come to you, ask, it's not everything that we take to court to. We start by writing letters. You come to me about an issue, I don't go to court. Lawyers, you don't like going to court. Look, court is not a good place to be. I'm telling you, for man.
We've just seen that.
Yes, I'm telling you. It is not a good place to be. People who have problems, people who have issues, people who have mental stress go to court. So normally, lawyers, look, it is better to resolve your case and have your money. If you bring a matter before me, and then I'm able to write to my colleague lawyer, and then we are able to resolve it, I take my money. And it can be done in 1 hour. You see the thing? Because going to court, the issue may drag. So at times, we resolve issues through exchange of letters and documents. I write to my opponent's counsel, my opponent, that this is what my client have brought against you. What do you have to say? Then you also show it to your lawyer, and then the lawyer will respond so that I'll know. Because at times, our clients, they always say that lawyers are liars. We are not liars. It is our clients. They come and then give us instructions. Based on the instructions, we act. So my client comes to tell me the size of the story and put it on paper and then give it to the person who has the case against. The person also engages the service of a lawyer. Then the lawyer to respond to the story. Then I will be able to know the truth. I confront my client in maybe conference. Go to conference, look, this is the letter that has come. What do I have to say to it? And then we look at the law. And then we respond. And then, so at times, through correspondence with lawyers, we even call each other. We can even decide to meet. Then we can resolve the issue without going to court. And by so doing, it is without prejudice. Meaning that we don't, if we are able to resolve those issues out of court, or we fail to resolve, we don't bring those matters in court without prejudice. We look at the issues, we resolve it. If it's able to resolve, we end there. But if it's not able to resolve, you realize that once we keep on writing, we'll be narrowing the issues. We'll be admitting, there are areas of controversy. We say, okay, now we've realized that this is the area we are able to resolve. This area, we are not able to resolve. So therefore, these are the issues that I think that we can go to court for the court to. And then when we are going to court, honestly, let me put all my cards. Let my opponent know what I have. And at times even details as to what I have. At times some of the charges, if you talk about defamation, give me the breakdown. If you talk that I've defrauded you, give me the particulars. Let me know how I defrauded you. All these things we do for the opponent to. But if you don't do that, the court will not allow you to leave evidence on it. The other opponent, when it comes to trying to hide something, the opponent will raise an objection that is not part of your case.
Because we heard in the Supreme Court a few times, oh, no, I don't know where this came from.
Thank you. If you don't plead it, if you don't put it in your affidavit, you cannot speak to it.
Because I was arguing that, well, we don't care. What do you mean you don't care? I mean, it's part of the case.
Yes. So the court will not allow you. You either have to go and amend, seek leave to amend, and then bring it and become part of a case. At times, it can be a disaster for you. The court will know, your opponent will not allow you. Then you move on. So that is the essence. We are in court to establish the truth. We are in court to help the court to know exactly what are the controversies.
Let me come back to Robert. Robert, if the High Court, is a case of record, and we see for 8 months, everything that is said has been recorded?
That is absolutely correct. Everything that has been said in the courtroom has been recorded, both audio and then transcribed, so that they could give it to the parties to study. Because don't forget that at the end of the day, there's a law that will be used. So
you and I were not there, everything is recorded.
And indeed, the document is now a public document. After the judgment, everybody can go and then obtain a copy and study it. In fact, it will be recorded in the court, reports, the law reports, and it will be available for everybody to read. And let me add that when you go to court and you make a case for 50,000, and that is where your case ended, and you didn't talk about 100,000, you are stopped from raising the 100,000 issue. Because you are told that bring your case, then the court will set the issues for trial. So it's not at that moment, after you've gone through the issue that we are going to try, that you are going to bring a new issue. That's why my colleague said that in that case, then you must make an application supported by evidence, or as it were facts, justifying why you are now seeking that amendment. Because if you knew those facts were available to you and you didn't bring it, you cannot bring it now. But if it was something that you didn't have that information and you have now gotten it, then you could convince the court that, look, this is also part of my case, but I didn't have that information, so allow me to bring it. Because at the end of the day, we are in a civilized society where, unlike in the old case, when you have an issue, then you fight with the person. Now, let the person know that this is the case that I have against you. If he also seeks advice on it, he will know that, look, I don't have a case. He will then just withdraw, and then maybe the matter is settled before even going to court.
With the Supreme Court case, what we noticed in the beginning was that the judges told all the parties, go and tell us how you want us to proceed on this case. So they will go and sit down and decide that we want to go via affidavits, or we won't talk about this. I mean, what were they supposed to come and tell the court? Because as if the court were waiting, you tell us how you want this case to go, and then we'll go that way.
No, not really so. With this petition, not really so. There are laws, rules set up guiding the petition. And I think the CI 75. So it was a petition that even the rules tells you when to petition, the day is 21 days, and then also the content of the petition come out, must follow, and And then what you do is that when you petition, there's a process where you have to file.
Because you remember, they seem never to reach an agreement.
Yes, now
so
eventually, I'm coming there.
Oh, you're coming there.
There. So after that, you serve your opponent then answer. And after answering, you realize that there will be better particulars. That is where you begin to trade, accusation, counter accusations. Then you know the issues that the court must resolve. Now, what happened was that after the petition have served, and then the respondent have also answered, then they said, we want better particulars. Some of the things were so generalized. So we want you to give us details. All these things were done. There were amendments here and there. Now you get to a stage now when the courts realize that, look, if you have done so, now let us know the issues for trial. Let us know the issues that are meant for. And then the court decided that, look, this is a fresh case. We are all gray area, so we don't know whether to apply the High Court rules. So you realize that the petitioners took the point that, look, with the High Court rules, there's something we call application for direction. Mm-hmm. So they came with application for direction. And then the respondents said, no, this application doesn't apply. So they brought in another technicalities, and the court said, look, whether application for direction or no application for direction, all that is that we want to know the issues at stake. Then the court gave them an opportunity. You are the ones who are fighting. We don't want to impose our view on us. So go and then look at the issues for controversy. Go and then raise the issues that you want us to try to look at as issues for us to determine. Mm-hmm. They went and they could not see eye to eye. And I saw it coming, because when you have these two people, they would never, some of them will raise 300 or 1,000 issues. As my colleague here, we have some lawyers, if you allow them to raise issues, they will raise unnecessary issues just to make sure that the case will drag along. Whether or not it is right to eat, then whether or not if you eat in the morning, so people can raise, and if you have a lawyer who is very, very technical and very controversial, he can raise so many issues that at the end of the day, them simple issues. So when the court gave them opportunity, they went, and then the issues they could not resolve. What did they do? They have to come back. And they started to call, my lord, we tried to raise the issues, but look as if some of the issues, there was controversy. Then they just said, look, then allow us. We gave the opportunity. We didn't want to lord it over you. Mm-hmm. So the court then went. In their own wisdom, realized that, this issue is simple. Simple. All after reading through the petition and then the answers and everything, they said, look, it is either whether there are constitutional, statutory, malpractice violations or those kind of things, and whether it's affected. So the court was able to narrow the issues to two, which was acceptable. So
then you go and come and prove.
Thank you. Now these are the issues for controversy. So that's why when we were trying, if you have a technical eye, you must look at the issues at stake. Some of them were addressing moving to each areas that does not address the issue. Some of the areas, and then at times you realize that the judges can bring your attention and look, these issues in controversy, the areas you are going does not address the issue. And normally it happens, we are all human beings. Somebody can drag you away from the issues. And normally there are some people, when the law is on their side, they talk about what facts and stories. So when you don't have the law on your side, what do? You create a lot of controversies. And I can tell you, anybody who is a very good litigant know when to raise unnecessary issues. And then there are some people, if you don't have a judge who is solid, you go to court and there's only two issues. Somebody can raise unnecessary issues and divert the court's attention on the necessary issues. But these judges are the experienced one. So at the end of the day, they were able to narrow it to two. And that is the issue that they'll be dealing with.
Robert, why 9? Why not 7 or 5? Was there any particular reason why 9?
Let me say that the full bench, as it were, the full complement of the Supreme Court, when they are sitting, is usually 5. That is the sitting of the Supreme Court. But the Chief Justice can empanel any number from 5 up to the number that she wants to happen. So for this case, it could have been 5, it could have been 7, it could have been 9. Of course, looking at the issue of possibility of a review, they will have to maybe allow, if they bring all the, I don't know how many justices that we have now at the Supreme Court, but the justice says not less than 9. So assuming we have about, say, 15, and they were to have put all the 15 on, then how would the review be? Mm-hmm. So in the court's wisdom, I think if you can do a 5, and in fact, I know this is a national issue of importance, and maybe we should give opportunity for all the justices to pronounce on it. So I believe that's why they opted for 9. I would have not had a problem if it was even 7. because the Supreme Court can be properly constituted with 5 justices.
Okay.
Exactly. Now, on the issue of the issues that was being settled, let me say that generally as issues, when you go to court, you have taken a case to court. You start with your statement of claim, or as in this case, your petition, asking the court to do certain things for you. Now, therefore, you have problems that you want the court to resolve for you from your perspective. So you'll be telling the court that I want you to solve this question A, then question B. And then after you've solved the question A and B, come to this conclusion that I'm seeking as my reliefs. So you will set out your issues the way that you think you want the court to look at it from your eye. Then the other person may also bring what you call other additional issues, or I would say counter issues. So that you two will say that, look, court, don't only look at what is A, what is B, but look at what is A prime and B prime.
Okay.
So that when you get that, maybe when that is also resolved, it will also favor me. But in this case, as my brother said, they couldn't agree on which should be. Because you see that the issues could have been whether or not there was overvoting, whether or not there was no signature. But the court just said that, look, all these things is a matter of irregularities. So let's look at it as, were there irregularities? And if so, does it affect? So I think that shows that the court, they are seasoned justices, because don't forget that they've been through the High Court. Some of them even started from the Circuit Court. The Chief Justice herself started very low and rose up to that. So they are seasoned justices and they know what they are doing. That's why I believe they set out those 2 simple issues for us.
Robert,
but it's pregnant a lot, although they are 2, but it's very pregnant.
I'll stay with you. The televised, has it done more good than harm? Has it done more harm than good in televising, bringing these justices, into a living room? And these are, gods, a bosom that, you don't go to just like that. And here they are on our televisions, for hours on end every week. I mean, has it been good or has it been?
Because the matter has not ended, I wouldn't want to comment seriously on that one. But let me talk about the issue about publication or publicity of proceedings. The rules of court says that every proceeding must be a public proceeding where you can allow people to participate, or as it were, attend the court and observe, unless the court decides that, look, this hearing must be an in-camera hearing where we don't need to get people to be there because the issues that we are discussing are very sensitive to national security. So on that score of making the hearings of the court public, I would say that maybe giving it in a television view would also be in line with making it public. Regarding the details of the present one, I want to hold my comments because the court is still in session on that one.
I want to raise issue with that. I think I am so much excited that they brought the cameras. You see, what it has done is to allow the ordinary person, even who does not understand the language, is watching. And it has brought a lot of what we call a lot of pressure on the justices. In the first place, they are not used to camera. And then we have a situation whereby the whole international community is watching them on the internet, on the DSTV and every network, and then you realize that what it has done to them is that it has made them also being under some form of judgment. We are also judging them as they are about to judge the case. We are also judging their demeanor. We are looking at the judges' conduct on the bench. They are looking at their utterances. We are always looking at everything, and we are looking at how. So it's like it has brought some kind of not pressure alone, but accountability. Look, the all eyes is on you. And normally it is good because we say that justice should not only be done, but be seen. People should see. Can you imagine what will happen? Can you imagine what would happen if they decided that, this case have this security apparatus, so they are going to do it in chambers. So it's only the lawyers, and they
come out and give a press conference.
They go into chambers, and then after everything, they come out. You see what is going to happen. Because the other person will say, hey, Kululu, these people are going in, and then it will be 2 accounts. The petitioners will come out and say that, this case is how we presented it. But now they have come out. We are seeing the performance of the lawyers. Those who misconduct themselves, we saw it. Those who could not articulate well, we are seeing. So it's given an opportunity for us to see. And when you see, you say, see is believing. Now, because people are seeing, now you realize that the other person is like, law is so difficult. People are saying that, we don't know that. We thought law is so technical. We've demystified the law through the live telecast. People are now understanding second legal jargons. What is examination in chief, cross-examination, those technicalities, amicura, all those things. People are now beginning to understand what element of surprise and then affidavit. These things can only happen because we've allowed, open the court toward for the other person to view. So to me, it is a good thing that has happened, and the justices are under some kind of pressure. You cannot do anything unless than to come out with the truth. Because listen to me, all of us are watching. And when our eyes are watching, it's very difficult for you to steal. And then spiritually, people are also looking at what is happening. So you have a situation whereby the judges have a duty to shame everybody. Come out with the ruling that everybody will know. So because if as we've watched the proceedings, if you come out with the ruling and you are reading the judgment and it's not reflecting what we all witness, everybody will know that this is what is happening. For example, you are making certain statements on your ruling and referring to somebody's, and then it will surprise you that people have recorded the proceedings. People have it. People sat down and decided to also write. You see that Jesatuba was writing. So people too were writing. So people have them verbatim. So if in your judgment you refer to somebody doing A, B, C, D, and people will also judge you. And the Supreme Court knows that immediately after the judgment, people will begin to critique. They cannot run away from that one. People, academicians, students, lawyers, judges, we have retired judges who will also be looking at their work. So they know that their work will be tested. Their work will go through fire. Bible says so. It says our works shall be tested through fire. And then we find out whether they're able to do what is fair and just, whether they're able to deliver judgments based on the evidence. You see, I'm saying that all the judgments should be based on what we witness. The only thing that you can do judgment outside evidence is when you take judicial notice of something that you can defend. But all your judgments should be based on what actually happened. Evidence that are admissible, evidence that that there were no question. So that is what we are expecting. We are all seeing. And so it is good that we have this live telecast. And I can say the negative is more. We can compare it to the cost or economic cost to the nation.
Robert, this I speak for myself. Maybe because I've never been to a Supreme Court before. But there's always, with all our institutions, there's always shrouded in corruption, no fair play, injustice. Always police, pastors, teachers, political parties. But for me, what those people, all those guys did was exemplary. I mean, it was fair. Whoever was wrong was told off. Whoever was right was commended, as it should be. So it wasn't the proverbial, oh, these guys are corrupt, these are, so I don't know. I don't know if you get what I'm trying to say. I was very pleased and proud to see them go through that thing, because every institution was always tarred with a corruption brush or a bent brush, but they came out clean in my books.
That's a good observation. And let me say that my brother said the court is probably under some pressure because everybody has watched them. Mm-hmm. I will say that even if it was not telecast, the judges have sworn an oath to apply the law fairly based on the evidence. So that one, I will not doubt their integrity to apply the law as they know it. Now, having said that, I will say that with issues of the court, somebody will go to court and maybe genuinely lose the case, but he will still be dissatisfied because he thinks that his case was not accepted. So always there could be a judgment, but somebody might be disagreed. But what we just want to say that if the court speaks, that is the final court of the land, and therefore it has spoken. That is the law.
We'll come back because I need to dedicate time for that. So I want to take a quick break because that statement, we need to reiterate it. Just to say that Star Ghana, in conjunction with Joy News TV, is bringing you these courtroom procedures and basically sensitizing us what went wrong so you really understand when the judgment is passed. We're going to take a quick break, and then when we come back, just to let us know that whatever the judges say is final, and then there's a review. This review business, we need an education on it. Stay tuned. Well, welcome back to the show again. Let's just say that Star Ghana and Joy News TV are bringing you this education just so that as an average citizen like me, who's just done Law 101, which is basically nothing, you seem to understand what went on and why it goes on that way, so that you don't have any underhand thing that, oh, somebody is doing any dealings. One, I commend the judges because, I haven't been to Supreme Court, but I think that for all our institutions shrouded in some darkness or some corruption, they have come up exemplary, so we recommend them. And when they speak, it is final, Doctor.
Yes, it's final. And let me tell you something. The reason why you have to, Ghanaians must have some kind of confidence in these justices is that they've seen it all. They are not young. They are not now looking for work. The average age of the justices is almost 50 years plus. Some of them are about to go on retirement. So they are men of substance. None of them there is a man of straw. They have their houses. They've been able to make it in life.
They're not looking for money.
So they are not bribable. Take it from me. Nobody can influence them. They are looking for something. Their integrity is at stake.
You can't sack them either.
You can't sack them either. They are secured. Now they are properly catered for by the state. And they don't trust the politician. You see what Atuga said? You are a few minority. And you go out there and misbehave. So they can't trust them. They will not be influenced by any politician. Ain't no politician, when you can go and take $100 million, they will not accept it. Because they don't trust you. You use them to blackmail them. You use them to blackmail them. So people should rest assured. Let's relax for these justices. They are going to defend the constitution. They are going to defend the state. They are going to defend the truth. And I can tell you.
And they're a good name.
I'm telling you, they're a good name. Because I know the netizens are making history. They want one day when they leave this earth or they are on retirement, their judgment will always be read for generation to come. So I'm so much confident in them, and they've shown it. You can see from their demeanor that because nobody has influenced them, they're able to talk the way they talk. But if there is influence somewhere, they cannot look into the eyes of the politician and tell them that, look, you are misbehaving.
Look at your size.
Thank you. Look at your size. So you can see the confident level. Now, you see, as we sit here, and my brother, if you are speaking the truth, you are too confident. As I sit here, if some political party they are giving me some money, you see that I'm talking, but I'm talking and watching my back because immediately I go, I'm accountable. They say, hey, news lawyer. But if the truth is on the side, so the justices will speak the truth. So let's commend them. Let's have confidence in them that they will do the right thing. They will do what is just and fair. And I can tell you, we will all somehow be proud that we have such justices looking and protecting our democracy for us and our constitution. And I believe that all of us will be proud. At the end of the day, they will make Ghana proud. And then they will speak and the nation will be quiet.
They haven't given us any reason to doubt. Because even if you look, once upon a time, we thought Afarijan was, sitting in the right-hand side of the Father Almighty. But they told him, you want to go to court, you see? And he suffered in court.
Yes.
They showed him that this was the ultimate power. And no, they took no prisoners, be MPP, NDC, or Afarijan, who is in the middle. Everybody who was supposed to be in line was put in line. So I think on that note, they have shown us that you have no reason to doubt me. Because
that's very correct. And let me say that, as my brother rightly said, they will do based on their integrity and their oath to serve the country Ghana. They will not be looking at any face or somebody has gone to see. It will never happen. So the verdict that they will come out with will be based on their conscience, their understanding of the evidence and the law, and their oath to Mother Ghana. And I am sure, 100%, that they are incorruptible, and they will give the verdict perfectly. And therefore, Ghanaians should be assured and take the verdict as it comes.
Studying the history of Ghana with, military coup and this and that and this and that, and even the general ignorance about the average citizen, because prior to this, we didn't realize how supreme the Supreme Court was. I think this is the opportunity to seize what is actually theirs. And they haven't messed it up. To show that, this is what we do. We are here to protect this constitution. And they have shown it. And I think they will use this opportunity to show that the power is not with the executive, but it is with them.
That is so. And that goes to show the independence of the judiciary. My brother said that, look, they are well paid and everything. In fact, you cannot say that you are dismissing a Supreme Court judge. There are rigorous procedures. He is secured in office. You can't touch his money when he's on retirement. So he has no reason to be corrupted. And let me say also that looking at what they have done in court, clearly everybody sees that, look, these judges are doing their call to duty. And for me, as a lawyer, I will say as a fact that I trust and I'm confident that whatever decision that they will come out with is because of what they understood as the evidence, and then they apply. As my brother said, they should apply the law to the evidence, and everybody will see that justice has not only been done, but it's manifestly and clearly done to the public.
And you know one thing, the reason why you are now seeing the powers that the Supreme Court have, is that there is power in law. You know, because currently we are governed by rule of law. It's the law that is governed. Gone are those days where the gun was governed, and we are governed by whims and caprices of those who come. Now, because the law is supreme, the law has become so powerful. And there's this saying that if you know the law, you become so confident, powerful. There's a saying we say that, and the Bible says that, and ye shall know the truth.
And it shall set you free.
Shall set you free. I'm saying that, and ye shall know the law. And the law that shall not only empower you, but shall set you free from your oppressors.
Let's do a review.
If I will add, you see, the Supreme Court in Ghana is like God.
Thank you.
Ghanaians, our God is the Supreme Court.
Yes.
In the natural sense. Because if the Supreme Court were to say that today, Kingsley, you are banished from Ghana, I'll be banished. If they say I should be killed today, that's it. If I go to the High Court and say I should be killed, probably I will go to the Court of Appeal and make an appeal. And then from there go to the Supreme Court. But when they say, the Supreme Court say that this is what it is, that's what it is. So that is the authority of the Supreme Court. They sit at the apex of the society and look down on us to apply the laws that we have put in the Constitution and enshrining them to, as it were, interpret and use it to guide us in our doing.
And for our own protection, we need them to be...
But also, let us also educate the public. They are not thingos. They are also, every actions of them is subject to the Constitution.
Exactly.
That's why they say the independence is subject to the Constitution. And also they have code of ethics. There are things, the do's and don'ts of the professions. And then you can remember recently, a judge was jailed.
Exactly.
So they are not above the law, yes.
Exactly.
So judges are not above the law.
So it's the Constitution.
It's the Constitution that is above. It's above Ghana. Except that judges are the ones who have been given the right to interpret.
That's why I said that they always say that the law is in the bosom of the judges, but the Supreme Court, the Constitution is above them. It's not in their bosom. The Supreme Court is above them.
Let's look at the review. IEA is saying that, whatever the case come, don't go to a review. I don't know what.
I'm somehow disappointed with the IEA. I think there's so many issues that they should deal with, but not this issue. When Benabona have gone to court to challenge the constitutionality of a legislation, and the Supreme
that
Court
was in the Constitution.
Yes, Constitution.
So it's not changeable.
It's a right. The right to review is a right given by the Constitution. So now, if you are begging people not to exercise that right, what kind of begging is this? You see that thing? So that's why I'm sorry. There are so many.
The law is the law.
The law is the law. You see, even they can go even sign, but that begging, that signing is not binding on them. That signing, if they go and sign that, we have agreed that we will not go for review, and if it's a written binding legal document, it will not take their right. It will not take their right under the Constitution. Your constitutional right to review is secured. So I was surprised that they are making this an issue, and not only that, currently instead of us looking at the way forward.
But in the interest of patriotism, can they plead that look? Let it go. I mean, there's another 3 years left. You can try your luck.
You see, let me. I support strongly, my brother, your statements, because it's very unfortunate that people will be begging and holding people's leg. Don't take it. Why? The laws of the country have been set down that if the Supreme Court takes a decision, they are entitled to review it if they so wish. Obama came to Ghana and said that let us build our institutions. This is a case for us to build the institutions of the judiciary, where if somebody feels that, look, the decision that came, I'm somehow disagreeable to it and I think I have a grounds to apply for a review, allow the person to proceed. We should allow the system to, don't beg And this, it's so unfortunate.
As far as the begging are concerned, you know.
Let me, I think the IEA, I don't know whether they have legal counselors. No, see, let the other person know that, please, when you talk of review, it's not going to be a whole trial. You know, I think people...
And it's not an appeal.
Because we think it's going to be a whole 8 months again.
No, it's not 8 months again, please. It's not 8 months at all. That's why I think that's where the case comes to be.
See, that's why I'm saying in the interest of patriotism, because I believe...
So I think the other people are fearing that, look, review is like we are going to start all over the case. No, the review, I can tell you for the man, it is even highly, at times, difficult to get a review.
Exactly.
Because there is a condition, precedent, that you must meet. Exceptional circumstances, at times, your review powers are taken away from that end. When you don't satisfy exceptional circumstances, you cannot even go for a review. So that review will not even take. I don't think it will take maybe 1 month or 2 months. No.
And it's not a matter of course that you have to go for a review. I believe that at the end of the day, if the decision comes, lawyers and counselors will look at it and say that maybe this one is a fair decision. We cannot do anything about it. There is nothing legally wrong.
I was under the understanding that for a review, you bring a whole different set of judges, we go back to court and start afresh.
No, we don't
Not
start
at
afresh.
all. Not at
You
all.
just add about 1 or 2 judges to the
Exactly.
one, and then the same case. There's nothing like bringing new evidence. There's nothing like coming to the same case. You make it a case for review.
And let me add that they will pick the recorded evidence.
Yes.
The record of the trial. That's what they will look on. So they will not bring somebody now to come and testify again.
We forgot about this one, so we are bringing. So no.
And you see, when you are asking for a review, you are saying that, look, my lords, you said A, but when you said A, maybe this A that you said is against this particular law, and maybe you didn't address your mind to it. So have a look at it again, whether you may not want to change your mind. They will look at it and say that, no, we don't think, we took a note of it, and we don't even think that your interpretation is the right thing. So go away. A review is not an appeal. It's a limited, so people should not be afraid. And this kind of begging people that they should not go for a review, I think they should rather look at begging people to just not maybe be violent when the decision comes out, accept it in good faith, but not to say that don't go for a review because it will polarize the country. I
can remember Amekuris came for a review. You know,
he did.
Yes, his first application was thrown out.
Yeah.
Then he came for a review. But unfortunately, it was not technically competent because the procedure. But it could not meet the requirement. So please, the review is not going to take even 1 month.
The second time was a review.
It was a review.
Exactly.
He wanted to review.
It's not as bad as
so it's not as bad. So please, so the IEA, please rest assured, review is not going to delay. The people should exercise it. So that to bring finality to the matter.
You raised the topic, you raised an issue yesterday, which, you know, is this new culture where we are telling people, oh, when you know, you go to the president, you go to another, oh, when the Supreme Court, please accept the ruling. And, you know, we are told, you know, there's no option.
What option do they have? Nobody has an option not to accept. In fact, if anybody decides that he's not going to accept, let me use for hypothetical purposes that were the president to say that I won't accept it, it would be a grounds for impeachment. Because nobody can override the decision of the Supreme Court. You have to accept it. And we have come from where Salah and Attorney General,
yes,
where the government said no court can do this and that. That's why now it's in that nobody, not even Parliament, can override the decision of the Supreme Court. If the Supreme Court pass judgment, the Parliament cannot pass a law to sidestep the decision of the Supreme Court. So they have no option but to accept. That is so. You have to accept the verdict. You don't have a choice that you won't accept the verdict because that is the decision of the final court.
And I think today what we've wasted the whole today. Political parties were going. They went to the Nado, pleading and begging as if honestly, let me make these statements. I don't know how controversial it will be. To me, in my opinion, what they were doing is it amount to undermine the authority of the court. To me, that's why I say it's like you are trying to say that some people are more powerful than the court. That even when the court makes decisions,
out of benevolence, they have to accept it.
Yes. What kind of court are we? And this is the signal that Justice Atuba gave. That look, they are exercising the authority of the state. So the sovereignty of the people reside, the sovereignty of Ghana reside in the people. And on behalf of the people, the authority of the state is being exercised. And the judiciary said the justice emanates from the people. And on their behalf, the justices will exercise. Therefore, Nanado, the president, has no option. Nobody should go and beg them. Nobody should go and beg them. They are not above the constitution. They are not above the Supreme Court judges. The Supreme Court judges, when they make orders and directions, they don't have any options. But failure for the Nanado to obey has its legal consequences. And failure for the president also is a high crime under our constitution. So I don't see the reason why we waste our time going to beg what, who. And this is what Atuma is so mad at. It's like we have pumped the politicians so long that now we are making them think us. Like we need them to beg them. So when even the judges are going to, the verdict is going to come, it will take them either to accept or to reject. You don't have any options. The ordinary Ghanaian, rest assured, let's have confidence in the constitution. Let's have confidence in our Supreme Court judges. They are our savior. The politicians have failed us.
On that note, on that positive advice note, now those of you who haven't listened to my program before, tomorrow 2 p.m. on Joy FM, tune in to a program I call That's My Opinion. And we'll be talking about something about this issue. But I think it is imperative that you and I defend this constitution with everything that we have, and indeed give these powers to the Supreme Court, because it intends to defend us. If we make the mistake and give the power to the politician to give them the option to defend, otherwise you and I, the hustlers, will go and hit the road, I think we can kiss this country goodbye. So these lawyers have really spoken well, that when the Supreme Court speaks, they have spoken. So far as there's life, there is hope. And I think we will. I'm sure we will. We will defend the Supreme Court. Doctor, thank you very much. Dr. Morris, Robert Kingsley, thank you very much for this advice and this education. And I'm sure it's gone down really well at Star Ghana. Thank you very much. My name is Nana Sakwa. Tomorrow, we'll be back here with Personality Profile. And it's been an education. Thank you for watching.
Somebody should advise them. Maybe they should have their lawyers.
Do they have lawyers? I don't know. You go and make unnecessary. And then you have.